Hey everyone, welcome back to Objection Psychology, the podcast where the human mind takes a stand and meets the law. I'm your host Lazaro, and today we're going to be diving into a concept that sits right at the crossroad of psychology and law, which is mens rea, or in more plain English, the guilty mind. We're going to be asking the question, can we actually know what someone was thinking at the time of a crime? Or speaking more provocatively, can we ever be 100% sure that someone intended to do harm? Today's episode, we're going to divide it into, I would call it segments. So we're going to have 4 segments in this episode. It's something that I'm trying something, different. Something to kind of make it easier a little bit to follow along. And hopefully make it also a little bit easier to understand depending on which section we're talking about. So to dive into the first segment, we're going to just go ahead and start with the basics. What is mens rea? So to start, like I said, with the basics, in the legal world, mens rea is referred to the mental state that a person must be in while committing a crime in order for it to be intentional. Now, there are different levels of mens rea. There's negligence, recklessness, knowledge, purpose, and obviously all of the variations that come with all of those terms. The higher up you go within these terms, the more serious the charge becomes. Now that we got that out of the way, from a psychological perspective, things aren't really so black and white as they are in the legal world. Because human behavior is shaped by a storm of thoughts, feelings, and unconscious motivations that are really complex even for current psychologists, previous psychologists, and just any human in general to understand. So whenever somebody pulls the trigger, literally or metaphorically, how do we really know what they meant to do? Did they really mean what they did is the question that is posed as, speaking of the concept of mens rea. Which leads us into our second segment, which is the neuroscience of intent. And in this segment, we're going to be talking the brain. Speaking of the brain, fMRI, or otherwise considered as functional magnetic resonance imaging, has given us a glimpse into how our brain processes intent, morality, and decision making. However, here's the kicker. Even with all of this technology, brain scans don't really come with subtitles. You can't really just point into a heat map and say, aha, this person's meant to commit a crime. It's not a minority report, at least not yet. That said, researchers are trying to, get a little bit of different stabs at this. A fascinating 2024 paper in the International Journal of Scientific Development and Research explored how fMRI might be used to evaluate criminal intent. The authors wrote, quote, "The prefrontal cortex plays a significant role in complex cognitive behaviors such as planning and impulse control, which functions highly relevant to decision making," end quote. And this was in the article mentioned by Kumar and Rajendran in page 3, if you're interested in looking further into that. However, speaking more in plain English, the translation is that if that part of your brain isn't firing properly, you might not weigh the consequences the same way the average person would. Speaking of, another major figure in this space is neuroscientist Kent Kiehl. Sorry if I mispronounced that. That's just the way that I kind of read it at first. But Kent Kiehl has spent years scanning the brains of incarcerated individuals. And in a 2013 study conducted by him, he found that inmates with lower activity in the anterior cingulate cortex were more likely to reoffend after release. Kiehl explained this, quote, "You can think of the anterior cingulate as the brain's conflict detector. If it's not detecting conflict well, that person might not pause and say, should I be doing this?" End quote. Kiehl, 2013, as cited in Wired. And then there's the dorsolateral prefrontal cortex, otherwise abbreviated as the DLPFC. A 2015 Neuron article by Buchholz et al. Found that disrupting this area changed how people judge punishment and moral blame. That's right. Whenever this part of the brain was temporarily inhibited, participants gave out lighter punishments. Surprisingly, unsurprisingly. So different brain regions affect how we process rules, risk, and responsibility. How much of criminals' behaviors is actually under someone's control? How much of intent is shaped of biology versus by choice? These are all the questions that researchers, even today, are still actively researching. And that makes us even pose more questions. So if people are less guilty because their brains are wired differently, what can we really do about it? What is the legal process in court towards these people? Does it make them different? Does it make them more dangerous? What really happens to these people? That's a question that, as we all know, is still being answered till this day. And with how more complex the human brain keeps growing, with how complex its emotions seem to be every time we examine it, how every part of the brain, every time we look at it, seems to be involved in an ever-evolving process. With that being said, there's a lot of conspiracies that we could get into, but instead, let's bring in a real case. This takes us into segment 3, in which we'll be doing a real case study, the affluenza teen. So in 2013, a 16-year-old boy, Ethan Couch, killed 4 people and injured several others while driving drunk in Texas. His blood alcohol content was 3 times the legal limit for adult drivers, and he was set to be speeding approximately 7 miles per hour in a posted 40 miles per hour zone. This case really shook the nation, but what truly ignited the public outrage in the end was his defense. Couch's legal team argued that he suffered from affluenza, a term that suggests that his privileged upbringing left him unable to understand the consequence of his actions. In other words, it was deemed that his mens rea was not guilty, and therefore he wasn't really present in order to have been guilty for this incident. Psychologist Dr. G. Dick Miller, who testified for the defense, later expressed regret over using the term, stating, quote, "I wish I hadn't used that term. Everyone seems to have hooked onto it. We used to call people spoiled brats," end quote. The judge accepted this argument, and it sentenced Couch to 10 years of probation and rehabilitation instead of probable prison time. This decision was met with widespread criticism. Eric Boyles, who lost his wife and daughter in the crash, voiced his frustration. Quote, "There are absolutely no consequences for what occurred that day. The primary message has to be absolutely be that money and privilege can't buy justice in this country." End quote. The case sparked a national debate about wealth, privilege, and accountability in the justice system. Critics argued that a less affluent defendant would likely have faced a harsher sentence. Dr. Sunia S. Luther, a psychologist specializing in the effects of affluence on youth, questioned, quote, "What is the likelihood if this was an African American, inner city kid, that the judge would excuse his behavior and let him off because of how he was raised?" The affluenza defense highlighted the complexities of integrating psychological insights into legal proceedings. It raised critical questions about how socioeconomic factors influence perceptions of intent and responsibility, challenging the fairness and consistency of our justice system. This case really sparked the world and really set sort of a precedent on how these cases are dealt with in today's age. Whenever looking back on it, we ask the questions, did he intend to kill? Was he capable to think to intend to kill? How was Ethan Couch raised? Was he raised in a bad family situation? Did he have home problems? But the main question, it all brings it back to, did he intend to kill? And maybe yes, maybe not. But was he capable of understanding the consequences of his actions? This is where psychology really complicated the verdict of this case. As Ethan probably sits around there walking, with just what we would call a slap on the wrist, a lot of other people in the same case would have gotten a lot of prison time. Maybe in the most extreme cases, death penalty wouldn't have even been rolled out as part of the consequence as well. This brings us into segment 4, and we're going to be talking about bias, empathy, and the jury. And speaking of the jury, this brings us to the role of the jury. Juries are made up of people, and people have cognitive biases, and they have feelings, they have emotions, they have attachments. And whenever a defendant such as Ethan Couch looks remorseful, it reminds them of their nephew. And perhaps they might be more lenient and they might feel more for the defendant if it's such a young person that looks like didn't know what they were doing or didn't want or didn't intend to do it. If they come off as cold or different, they might be seen more as dangerous, even if the evidence is weak. But however, this wasn't Ethan Couch. Ethan Couch looked, and I was researching this on my own, I was researching this case, but he looked like very remorseful, and he looked like he had regret. And at the end of the day, we have to understand that these juries aren't just regular robots that are made to analyze empirical evidence. These are people, and these are people that have feelings and emotions, and maybe the juries that day at that specific time, which were selected for that specific case, felt like Ethan Couch deserved a second chance. Psychologists, however, call this the fundamental attribution error, in which we tend to blame people's character rather than considering the situation and not just looking, as I was saying earlier, at just empirical evidence. However, unfortunately, in some cases, fortunately for others, this bias can shape verdicts in ways we don't always acknowledge and can change the overall outcome of any case given. Closing it out, I'm not really trying to spend a lot of time here, but this poses, again, another multitude of questions. But it all points back to one. Can we read criminal intent? Not exactly. But, however, by integrating psychology into the courtroom, we can get a closer understanding on the why behind the what. And maybe, just maybe, that can lead to a more just system. One that doesn't necessarily just punish behavior, but also truly seeks to understand it. With that being said, everybody, I appreciate all of y'all for tuning in. Thank you once again for tuning in to Objection Psychology. If you liked today's episode, share it with a friend, drop a rating, hit me up on my email, and if you have a topic that you want me to cover and that you want me to tackle in the future, hit me up. I'm always open to any ideas and any insights, any feedback that you guys might have. But like I said, I appreciate everybody for liking. I appreciate everybody for downloading. And I truly couldn't do it without the support of everybody listening. I want to announce, I've had listeners from all over the United States and all over Germany, especially. I don't know what's going on over there, but if you guys want me to tackle a specific issue, specific topic, go ahead and hit me up. Always open to anything. With that being said, everybody, stay curious, stay critical, and as always, objection sustained.